All right, good morning, everyone. This is 24CV015715, which is, do we pronounce it Tseng?
Yes, sir.
Tseng versus the Georgia Composite Medical Board. I'm going to have you all introduce yourselves in just a moment, and then I'll give you my understanding of where we are procedurally, so you know what you don't need to cover if I got it right, or you know what you need to correct if I got it wrong. And then we can dive into this. Couple things about scheduling. One, I think this was originally this afternoon and you agreed to move it to the morning. Thank you. Two, I actually do have other things happening this morning. I am presiding, so people may be coming in. They don't come in and interrupt, but Deputy Gordon may be passing papers to Ms. Niles, and we may have to take quick pauses while I sign something to get people on their way. And three, I don't know how long you all want. You've got all morning, with one caveat. At 10, we have to stop wherever we are, and I have to go deal with something for about 20 minutes in another courtroom, and then I'll be back. So if you wanted a break at 10, you're getting one. If we're done by 10, it doesn't matter what I'm doing at 10. But 10, I got to be away for about 15 or 20 minutes, and then I'll come back and we'll pick up wherever we left off. We don't need to fit it into the 54 minutes, but it may be both sides. Hey, look, we have 15 minutes of argument, and that's great. I'm fine with that. I'm not making you compress it into that window. So with that said, who do we have here for Dr. Tseng?
Your Honor, I'm Susan Levy, and this is my associate.
Your Honor, I'm Dylan McConnell.
Hey, Mr. McConnell, Ms. Levy, great. Thank you for being here and switching up. And on behalf of the board, I'm gonna call it board for short.
That's fine. We have the Georgia Composite Medical Board, Michelle Sawyer with the Attorney General's office.
Great. Thank you, Ms. Sawyer, for being here. So long history here. Dr. Tseng is arrested in 2000. You all are going to tell me why it took 4 years for his license to be temporarily suspended. 4 years later, he challenges that, has a hearing in front of the ALJ. The ALJ says, boy, based on everything I heard, which is some witnesses from the doctor, no witnesses from the board, you know what? There do need to be sanctions here, but Dr. Tseng can continue to practice, but with some limitations. Like you can't be around kids, things like that. So we're clear, the arrest was for the possession of child pornography. Somehow, and I'm going to need to understand the procedure from you all, the board appeals to the board, and the board says, we didn't like what the ALJ said, and we are going to revoke the license. And that revocation triggers Dr. Tseng's petition for review, which brings all of us together. And then Dr. Tseng pleads guilty in DeKalb County, is sentenced, is on probation, and is a registered sex offender right now. The board says, could we reopen the record, words to that effect, because we would like to incorporate into our findings that he is in fact a convicted, well, he may be first offender, but either way, he is on probation and he's a registered sex offender. I grant the board's ability to do that, and they issue a new finding, revoking again, but adding things to their finding. And we'll talk about whether it was a new basis to revoke or just a more complete basis to revoke. In the impact was the same in that there was a revocation of license and then again a revocation of license. Unsurprisingly, the plea of guilty or the plea and the requirement that he register as a sex offender didn't make the board think something less serious than revocation would be appropriate. So that's where we are. The Dr. Tseng's lawyers have filed a brief saying, here's why the first decision was wrong to revoke. So the board's decision after the ALJ hearing. And Ms. Sawyer, you've responded as to why the first decision was correct to revoke. Then Dr. Tseng's team filed a second brief saying, here's why the second decision to revoke was wrong. Different arguments. Hey, you reopen the evidence and maybe you acted as an expert and different things like that. I didn't find in the record a brief on behalf of the board saying, and here's why the second ruling was correct as well. So you're free to address the arguments that were made here in court. I just didn't find anything in writing.
Yes, that's correct. It's my understanding the order was, it was an optional brief, and given that we were set to appear before you, I
Yep.
needed to address it today.
Yeah, and I flagged that not as a critique. I just want to make sure I didn't miss anything. Okay, great. So I think that's where we are procedurally, with one caveat, and it's my first question, and it goes to Dr. Tseng's team. One of the first things in the docket is a motion to amend the petition. And through oversight on my part, I never really addressed that. I want to make sure that we're not going to get 20 minutes into this and then, Ms. Levy, you say, well, we need to stop now because you never ruled on our motion to amend petition. We need to amend it because without amending it, I can't make the following argument. And you may have forgotten about the motion to amend petition, which tells me we're good.
I think we're good.
Okay.
Okay, I think we're good.
I don't think you've waived anything. I should have reached out to the other side. Do you have any opposition? It's just because of how things moved along, I didn't act on it. So I don't want to preclude you, Ms. Levy, if you think amending the petition puts Dr. Tseng in a better position, then you could do that. It will delay things because if you amend it, then I need to give the board a chance to say, well, here's what we think about that.
I think we just wanted to make it more specific, but
Okay.
I think we're okay as long
Okay.
as the board doesn't object to all the rest of the arguments we've made in our briefs.
I have no issues with the procedure. So it's my understanding that they have 30 days to file a petition for judicial review after the final decision is entered. The first attorney, Mr. Rubin, did make that timeline by filing sort of a boilerplate petition for
Right.
judicial review without many facts, if you will, just sort of a boilerplate one, kind of like with the amended motions for new trial, just to make that 30-day deadline.
Yep.
I understood their motion to amend simply to allow them to make further arguments and
Okay.
brief.
And it sounds like they've been able to do that
Yes,
because
I feel like, yes,
Good.
I've been able to adequately respond to their briefs. I have no issues with it.
Agreed. The briefing has been extensive and I haven't read anything where the board raises as a defense to an argument, well, you can't even bring that up because your initial petition for review was so bare bones and skeletal. That's not how the Superior and State Court Appellate Practice Act was designed. You have to get in within 30 days, that placeholder of I want something reviewed. And you basically say, here's the decision that I want reviewed and here's the record below and here's who I am. And that's enough. And then you go forward. So, okay, then we're in a good spot. You are welcome to stand when you're talking. You don't have to. It's up to you. I can hear you fine. If you're seated, some lawyers, I can't talk if I'm seated, and that's okay too. All right, so we're all right with the motion to amend the petition. The other question I had, and I think I'll turn it over to Dr. Tseng's team. I'm going to ask this of Ms. Sawyer, and then I'll hear from Dr. Tseng. I understand my standard of review. I don't get to consider new evidence if someone tried to tender it now or anything like that. And I need to be fairly deferential to credibility findings, et cetera, of the board, not the ALJ, because we're now reviewing the board's decision. What I couldn't tell is, well, what was the board's standard of review? Did it have the same as I have? Or because it's internal, it's different, and they're not bound by the ALJ's findings, or they could adopt findings, but we're adopting them, but we didn't find them to be particularly credible. Because to me, that has an impact on their freedom or flexibility to depart from what the ALJ found without receiving new evidence, because I don't get the sense that in front of the board, new evidence was presented. There may have been argument, sort of like we're doing, but if their standard of review is we can do whatever we want because heck, we're the board, that's a different landscape.
I wouldn't characterize it as we can do whatever we want. If parties had wanted to present additional evidence at the agency review, they could. There is a mechanism where they could file a motion very similar to the additional evidence motion that was filed with this court to say, I wanted to present extra evidence. That didn't happen. Neither parties really had additional evidence at that time. So it was in fact just oral argument and review of the record from the ALJ. I
Okay,
will say that the standard by law that the board was using at the time is reflected in OCGA 501317A. And that says, on review of the initial decision of the representative, the agency shall have all the powers it would have in making the initial decision. And if deemed advisable, the agency may take additional testimony. So that is what they were doing. They were reviewing the initial decision by the judge. We will say in the state licensing board arena, the initial decision is considered a recommendation and uses language as to the recommendation.
okay.
So
So
the board
50
was free to overturn it if it did not feel,
It could reweigh the evidence.
yes.
I cannot,
It cannot
but,
take additional evidence, but it could reweigh the evidence.
okay, and what I would want to explore is 50-13-17A. And that sets out the standard of review for the agency, considering what you are now characterizing the ALJ's ruling is really more like a report and recommendation that a magistrate makes to a district court judge in federal court.
Yes.
That's sort of a parallel.
Right. The initial decision is a recommendation.
Okay,
I mean, I'm not going to say frequently, but often, due to the fact that frankly, the economy of the board is frankly just to rubber stamp that.
sure.
But that does not always happen. The law does allow both parties to file for agency review.
Okay,
If it had gone a different way, in any case, the respondent or the licensee at an OSA hearing could also file for agency review.
Right.
So both sides could do so.
Okay.
If they deem the recommendation was, ill-advised for some reason.
who represented the board? I don't, it may have been you. I don't mean the person so much as who is the board's representative in front of the ALJ?
Yes, typically it needs to be a representative from the Attorney General's office. Sometimes it is the same person that shows up at the agency review as well as here. In this particular case, it was me throughout the
Okay,
proceeding.
but the Attorney General's office has responsibility of representing licensing boards
Correct.
in proceedings like these.
Yes, in particular, my section, the state licensing board, has
Okay.
attorneys that represents all the 49 professional licensing boards in the state.
Okay, and so when a licensee has some issue that he or she takes to an ALJ, it's always going to be someone from that unit on the other side.
Yes, unless I guess it's possible if we had some sort of conflict or something along the lines.
But in standard proceedings, okay. Then who decides after the ALJ rules on the board side? Because obviously Dr. Tseng didn't appeal this. He's like, great, I can continue to practice. I'm not going to be a pediatrician anyway, so these restrictions allow me to continue to do the important work I'm doing. But it was appealed, and as I said somewhat flippantly, the board appealed to itself. But who makes that decision?
So how that works is all initial decisions from any OSA ruling is then, by the initial decision, I of course mean the physical initial decision, including all the writings, are given to the board. The board, of course, knows the procedure in advance. They voted to have that case sent to OSA, so they do have some knowledge and background of what occurred. But they review that initial decision and decide if they want to appeal it.
I guess they have to, because you said the ALJ, it's merely a recommendation. And so it may be 9 times out of 10, great, we approve, we adopt and make the ruling of the board what the ALJ said. Your license is not terminated, but you're suspended for a month, or you have to go to this extra training or whatever it is.
Right, so how the Administrative Procedure Act is written, in my understanding, is if the initial decision is not appealed by either party within 30 days, then it is automatic. However, we are required to write a written final decision, essentially just saying, we affirm.
Got it.
And making that part of the record and closing out that case.
It's sort of default acceptance or default adoption of the ALJ's ruling if no one appeals.
Correct.
Okay.
If one or the other side decides to appeal and files a petition for agency review with the board, delineating, I would like to be heard, then there is a due process right for them to appear before the board again, the members of the board, the appointed members of the board, to make their arguments, and the board will then make a decision if they want to be swayed by the arguments or not. After reviewing the whole record, there is a rule that says OSA has to transmit that record to the board since the board was not there. They review it and listen to the arguments and make a decision from that.
Okay, so back to my question. In this situation, would it have been the board looking at the ALJ's ruling and saying, we're not comfortable with that, so we appeal to ourselves? Or is it you or your office looking at it and saying like, I don't know that this was the right outcome, board, we think you should hear this?
No, so the board reviews the initial decision and makes that decision by vote. In this
Okay.
case, it was a unanimous vote. I don't think it's contested. It was a unanimous vote. That
It
was,
sounds like it's been unanimous all along with the board, unanimous to revoke the first time, the second time, and to review it initially.
yes, and of course, there was no request to make it part of the records, but all this is according to the Open Records Act and Open Meetings Act. It's in the minutes, it's filed in.
Okay.
There has to be an official board vote, both to have an agency review and also at the agency review to affirm the decision if the agency decides to affirm the decision.
Okay. Huh.
At the agency review, I don't want to misrepresent my role in it. At the agency review, I again represented the board, but we have kind of, I guess the best way to put it is a Chinese wall, that during the agency review, what occurs is I become sort of a different individual as the board's representative making the arguments. A second AG, Attorney General, will then sit in to advise the board during their deliberations. Myself and Ms. Levy stepped out during the agency review.
Right.
I don't know what happened in those deliberations.
Okay.
They discuss it, then they come back out, parties come back and they make their vote. Again, those parties making the vote being the members of the board.
Yep. Okay. So it's probably not a good sign for a licensee when the licensee is happy with the ALJ outcome and then he or she learns, well, the board is appealing to itself.
I will say, and I don't have any studies or anything along those lines, I will say that just from my experience of serving in my role, there has been probably more times than not that the agency has reasons when they review the initial decision to have pause or concerns.
Oh, I get that. And here they did. I'm saying if you're sitting in the shoes of the licensee and great, this went well, ALJ ruled in our favor. It's not Smith versus Jones going to a neutral body. It's Tseng versus board, board lost, and then board says, all right, now we're going to decide the case.
Right.
And there's nothing, I mean, structurally, I get that. I'm not critical. I just wanted to understand the process flow.
You're correct. There probably is some thinking that, well, I'm appearing against the same board that decided to review the decision.
Right.
That's sort of the question that we have here. Is there something odd about that?
It's not odd. It's just structurally different from what I'm familiar with.
Right, but that is, the board is in fact reviewing the decision. They're
Right.
told to look at the record. They have an advisor that tells them what they're allowed to and not allowed to look at, what they are and are not allowed to consider. And so the decision is made in that context.
Right. And that's where the buck should stop, is with the board anyway. If they're going to allow someone to keep a license or modify it or take it, ultimately the board ought to be responsible for that. Okay. That's all helpful in helping me understand how the process worked. Ms. Levy, do you agree that the standard of review or the statute that controlled the scope of the board's review of the ALJ's decision was 50-13-17A? Or Mr. McConnell? You guys are free to tag team.
Your Honor, 5013-17A does say that the board has all the powers that it would have at the initial hearing. I would just add that, and this is a case we cited in our brief, Professional Standards Commission versus Adams, 306, Georgia Appellate Court 343 from 2010, and
You said 306, 343?
correct.
Okay.
And this was a Professional Standards Commission case, but the procedure is the same. And I would just cite to this one quote that, in addition, the PSC, Public Standards Commission, is required to give due regard to the ALJ's opportunity to observe witnesses. So same situation here where we didn't have new witness testimony at the board hearing. And
So whatever due regard is, the board is supposed to give that to the ALJ's decision.
opportunity to observe the live test.
Yep.
Correct.
Okay.
So just if I may add, so in the beginning of your question to Ms. Sawyer, you talked about whether the board gets to determine the credibility of the witnesses, and that's not correct. I mean, the board never called separate witnesses. So the ALJ gets to observe the credibility of the witnesses and make those decisions. And then the board cannot just say, you know, willy-nilly, we just disagree with all this. And so.
And why not? If 50-13-17A says what it says, that when it's a review to the board, they really have the plenary authority they'd have as if it were originally argued to the board. So they could look over is the ALJ proceeding just a transcript, or is it could listen to it? What do the board, get to review of the proceedings below?
Well, there is a transcript.
So it's a transcript. It's dry. They don't hear voices, et cetera.
But I think some of the testimony was taken by phone and it was probably all recorded, so they may be able to do both. But to answer your question, I mean, the law says that
What law?
I cited it all in my brief, but several of the cases, let me just get to it. The board has to, if they want to impose a harsher sanction than the ALJ, then they've got to do it in a way that has a rational basis, where they cite the specific testimony, and it can't just be an arbitrary and capricious decision.
Okay, I understand that part, but if their review is more plenary than mine, then maybe I went a little too far in saying, though I don't know that it's prohibited, if they are able to, from the transcript or the audio, say, it just wasn't credible. This person kept saying yes to these questions, and the moment the other side asked questions, then they were evasive and they wouldn't answer. And so I don't find that witness to be credible. That's not this case. That's not what they didn't find the expert who said OCD, anti-pedophilia is a legitimate condition that you can have. But let's just go to reweighing the evidence. It sounds like under 1317A, the board is free to reweigh the evidence. And so don't we boil down to the end, is it really all that arbitrary and capricious for the board to say a guy who is a registered sex offender shouldn't be able to practice medicine?
Well, go ahead.
I'm sorry.
No, go ahead.
I would break it down and talk about each, there have been 2 hearings before the board. I would talk about them separately. And, here at the first hearing, and this is what we briefed the first time around, the board adopted all of the factual findings of the ALJ and then supported its decision to, impose this revocation as opposed to the restrictions by concluding that Dr. Tseng posed a danger to the public if he continued practicing medicine.
Right.
And that is in direct conflict with the factual findings and the legal findings that they adopted.
Well, if it's in conflict, then doesn't it mean they didn't adopt all of it? I read the briefs. I understand that it was sections 1, 2, and 3, but not section C. Somehow they're letters and numbers. And so, yes, they're accepting the expert testimony that the OCD has been treated, although it's incurable. But when they weigh all that, which they're entitled to do, they're not the ALJ, they weigh all that information, they say, that doesn't make us comfortable that it's safe for you to practice medicine. Appreciate what those experts said, but we're the decider here, and we don't think it's safe for you to practice medicine. How is that an overreach? I mean, to me, I know we have the added complexity if there was a second decision, but set the second decision aside, because even if that one crumbles, you guys run into the first decision where they maybe didn't reopen the evidence, et cetera. This is what I was going to press you on when you made your argument. I haven't let you do that yet. I apologize, but we're cutting to the chase in one respect and we can work backwards. How is it arbitrary and capricious for a board that has the ability to reweigh the evidence to say, we accept this evidence and these facts, but we're now the new jury, and 2 juries can hear the same evidence and come up with different verdicts. And the problem for Dr. Tseng is the final jury was the board. And the board said, based on this evidence, it is not, and I don't think it's a particularly controversial finding. If you just take the view of a member of the public, like, wait, you are letting a guy who's a registered sex offender practice medicine? And it's much more nuanced than that. He's not a pediatrician. He's not setting foot in CHOA. He's doing research stuff and all that. I appreciate the distinction, but in the end, it doesn't seem like a remarkable thing to say that the board has the ability to revoke the license of a registered sex offender.
You know, I agree with you.
Okay.
In some ways. I mean, I think that.
So then we have to step back from that to get to where, you know what, they're stuck because sort of what the argument is board, you're stuck because pick your adjective. You were lazy, you were sloppy, you overlooked it, but the way you adopted the ALJ's findings, you didn't have the authority to impose a more severe penalty.
There is that, and that there's the case law. I really encourage you to read the Horn and the Adams and the
Tebow? We'll call it Tebow.
We'll call it Tebow. There you go. I'm sure Tim would mind, but anyway. I think those cases say it's not just as plenary, I think, as Your Honor is talking about. I mean, otherwise there would really be no reason to have this whole OSA process. And what the cases talk about is that when the agency makes a decision that is to impose a harsher punishment, they can only do it by pointing to certain things in the record that support it. They can't just say, we disagree.
Right.
And one of the reasons is, and I can't remember which of these three cases, I'll look at it in a minute, maybe when you take your break, but one of these cases talks about it also, if you would just let the board behave that way, then there's really no reason for you or the Court of Appeals. Because if the board can just substitute its own alleged expertise with nothing on the record and no ability to cross-examine them and just say, no, we just disagree with all that, how are you supposed to come in, or how's the Court of Appeals supposed to come in and make any ruling? Because nothing's on the record. They just kind of looked at it and said, well, we adopt everything that Judge Schroyer said, but but we just totally are going to ignore what she said on the other hand, and we find him dangerous and that he poses a threat to the community, counter to all the evidence that was listened to and heard by Judge Schroyer. And they cannot do that. And one of the reasons is it would just render this process a waste of time and money, because you have no way of looking at what the board did because nothing's on the record other than what the ALJ did and the board adopting that. Does that make sense?
No, it does. I follow that. The problem, what I struggle with is that you haven't addressed the scenario of reasonable minds differ. And maybe you are in saying they have to point to something in the record, but it seems like the way this is structured, the review process for licensing boards, is that the board is able to, I'm going to use my district court judge magistrate analogy.
Right.
Magistrate hears the evidence, does the R&R, and then the district court judge doesn't have a new hearing, looks it over and say, you know what, but based on that record, that's not the right thing to do. Or more personal perspective, the hearing panel of the JQC hears all the evidence and says, this judge has violated the Code of Judicial Conduct, and this is the sanction that ought to apply. And then the Supreme Court of Georgia, with no new evidence from the very same record, looks at it and says, yes, there were violations of the Code of Judicial Conduct, but that's the wrong sentence. We're going to impose a different sentence. No new evidence. They can't receive new evidence. But because they have the ultimate say, the board has the ultimate say, they're entitled to reweigh that evidence. We didn't need another expert. As the board, we think that someone who is a registered sex offender is per se dangerous to the profession. And I'm using the wrong words, I know, but I'm not seeing what precludes the board from saying, we see that same evidence. Understand that this expert said, well, but he's got this under control, and if he's not around kids, maybe we're safe. And the board says, we're not going to take that chance. We're not going to maintain a license of someone who's a registered sex offender. Not great for the profession, optically, but what if we're wrong? And what if that expert's wrong? It's just not worth the risk. So, and that's not what was articulated anywhere, but maybe that's what happens behind closed doors to which you and I aren't privy. But fundamentally, the board has the authority to reweigh all that evidence to say this to us rises to the level of a revocation. And they did, I mean, it's not that they pointed to nothing in the record. My understanding with the first decision that they point to this citation, they make this citation and that, they just pointed to something that the ALJ looked at and said limitation on license, and the board said revocation of license. And so that's still reviewable. If there was evidence that the previous 3 registered sex offenders didn't have their license revoked, why are they doing it to this person? That does seem capricious, that every 4th they go ahead and revoke. I suspect there aren't a lot of registered sex offender practicing physicians in the state of Georgia.
Right.
So you don't have that argument.
I think the cases just say that they can't do that. They cannot change the sentence without pointing to something. And in this case, they didn't just say, you know, Dr. Cheryl was wrong. Well, they kind of did, but what they did was they inserted their own
Expertise
for
which there's no testimony and which you didn't get to cross-examine.
Right. No, what are their qualifications? Some members of the board aren't even physicians. And so they just went in and they decided, you know, this is a pseudo diagnosis. When the board had every ability to, number 1, call their own expert, number 2, order their own exam of Dr. Tseng, and they never did any of that. I mean, it just would render the whole procedure before the OSA just an exercise in futility. And they just get to say, well, we think differently. And there is a case, one of these, the Tebow case goes and talks about the Hicks case. Is that Tebow cites Hicks? So the Hicks case, there was an issue of whether the person was depressed. I can't remember, but it had to do with depression.
Sure.
And so the board went in and said, well, we don't really believe this thing about depression. We think that it's a different kind of depression, and talked about like postpartum depression, blah, 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 blah. And that's when even in the Adams case, they talk about that they have to give deference to what the expert said at the trial, at the hearing, and to the judge's interpretation of that. And here, the board went further and even adopted those same findings. So, some of those cases also talk about guarding against a vindictive board. And I think that's exactly what you have here, is that this, and I'm not saying this board has done something insane.
Right. The vindictive, that's a tricky word to apply here. If Dr. Tseng had accused some member of the board, like, well, he's a pedophile like I am, I could see that. But this seems like a protective board rather than a vindictive board.
Well, it depends on who the vindictiveness is aimed at. I mean, here's a board that says, we really don't care that this judge, who's very experienced, heard these experts. One of the arguments made by the state has been, well, these experts are biased. One was a treating physician, and one was
the treating physician of Dr. Tseng. Okay.
And one was a paid expert. Well, I'm a trial lawyer. What are we supposed to do? If you can't have a treating physician and you can't have a paid expert, so what are you supposed to do? There'd be no way of ever having any kind of expert testimony. And in this case, we did what we could. We had both, and the state had none. So these doctors who are on the board, some of whom may be psychiatrists, can't just sit back and say, in my experience, I think this diagnosis is bullshit. Excuse my French. But that's really what they did, a pseudo diagnosis with no evidence. If they had said, this in the record supports that it's a pseudo diagnosis, or this other witness said that, or these are the reasons why it doesn't support the judge's conclusion, that would be one thing. But they didn't do that.
Is one of my remedies here to remand to the board to, if it is able, point to what in the record supports their decision?
I think that you probably can. I think one of those 3 cases said that you can do that.
I think it's in the statute that I can remand, say, look, you reached this conclusion, you didn't explain why. So either explain why, or you can't end up at that conclusion.
Well, and in some ways, they
And
had
explain is the wrong term, because they did explain, and you take issue with the explanation because it's the silent expert substituting judgment without an ability to point to the record. And so what I should have said is, I believe a remedy that I have, if I think it's appropriate, would be to send it back to the board saying, we need to try again. And whatever your conclusion is, if it differs from the ALJ, you need to point to upon what you relied in the record you adopted that yields this different outcome.
I think that's right, although they've had their second bite at the apple and they didn't do it then. I mean, they had a hearing again. They didn't call any testimony. And instead, we heard the chair of the board get up and just basically spout his theories and opinions on anti-pedophilia OCD. And say things like, well, it's not in the DSM-5. Well, it's a subcategory. There are a lot of things where subcategories of a diagnosis are not in the DSM-5, but we didn't get a chance to cross-examine the chair of the board on that.
Was there, how do you respond to, and we haven't heard from Ms. Sawyer on this, just your side, but what is your response to the pushback of, well, there was a second hearing, and they did have new information, and that was that now Dr. Tseng isn't, I've been arrested for it, but I pled to it, and I am now on probation, and I'm a registered sex offender. P.S. There's a statute that says that's enough to have your license revoked.
Statute was applied retroactively, which it shouldn't be.
How is it retroactive if the statute was adopted and amended in 2021 and he didn't plead guilty till 24 or 25? So he's not a registered sex offender until 3 or 4 years after the statute is amended.
I believe you look at the date of the conduct, which was 2019.
1920.
Huh?
1920.
Yeah, 2019 and 2020. So the time of the conduct, they could not revoke based on a conviction because that conduct was not related to the practice of medicine. This is a very nuanced argument.
It is. No. I have to think through that. And you're right, when it comes to criminal penalties, if you were using or selling fentanyl 6 years ago, and the penalties for fentanyl distribution last year went way up, you have to look back to the time of the conduct.
What about abortion? What about a doctor that assists in an abortion or help?
I can't really talk about that on the record right now, so let's use a different example.
Well, it's a rhetorical question, but if that conduct is not illegal and is later made illegal, you can't go back and arrest the doctor who did the abortion at the time it was legal. And take away their license for doing that.
Could be. I can't move around in that space right now, but I'll think through the ex post facto part of that.
And Your Honor, I would just add that the Georgia law on applying new laws retroactively doesn't distinguish between civil and criminal laws. It just states that laws cannot be applied retroactively to injure vested rights.
Okay. Well, why don't I let you present what you want to present for a little while instead of me peppering you with questions, although that will happen the moment you start talking, but you may have had a particular approach you wanted to take, and I didn't really ever let you get started.
Thank you. Well, I guess I'll sit here if you're really okay with that.
I am really okay with it.
Okay. And I'm actually, I guess I'll switch tacks. I was just going to say a little bit about my argument and then turn it over to the state, but I'll go ahead and outline more of my argument. So I want to talk about some things that are undisputed in this case. And one is that Dr. Tseng was a talented and exceptionally findings to a study of a lethal disease called pulmonary hypertension. I mean, he was really a star in his field. And until he committed the acts that form the basis of this case. He had no criminal record, no problems with the board. Undisputed that he was arrested in 2020 in June for downloading CSAM, child sexual abuse material, on 3 occasions. He has taken responsibility since day one. When he was arrested, he told the detective what was going on. He disclosed to the board, as you indicated earlier, on three separate occasions that he had been arrested.
So I actually didn't indicate earlier, I asked earlier, he's arrested in 2020 and nothing happens with the board until 2024. And I think from the pleadings, there's sort of reference to the doctor waved the flag of I messed up and it was the board that just didn't do anything. But I didn't have Ms. Sawyer's perspective on that. But what you're saying is that Dr. Tseng on 3 occasions said, hey, by the way, I've got this issue.
Yeah, he, on his first license renewal after the arrest, another license renewal on January 24th, and then when he applied for a compact license a few months later. All 3 times he disclosed.
But what years were those?
What was the first one? The second was January 24. I can get that. See, brief.
But his disclosures weren't like a formal letter to the board. It was as he's applying for something or trying to renew, there's a question on the form that says, have you been arrested? And he filled that out accurately.
Yeah, and you also have to then provide an explanation.
Okay.
So he did all that.
So he disclosed where required. It's not that he, as I'm asking, sent a letter to the board saying, hey, I don't know how you want to manage this, but this is particularly messy. I didn't get a speeding ticket, but I got arrested with CSAM.
Right. He disclosed, as far as I know, we can double check, and I wasn't representing him back then, but as far as I know, he disclosed when he was asked.
Okay.
All 3 times and explained it. We can get you the first year in a minute. So he discloses, he admits, and then he admits his conduct at the OSA hearing. So, nobody was surprised by the conviction. It was either going to be a negotiated plea, maybe there would have been a trial, but he's admitted his conduct since day one and did at the OSA hearing as well.
Do you know if the record made in DeKalb, which I guess could be part of the record that the board considered at hearing number 2, indicated something more serious or more extensive or more egregious than the way in which Dr. Tseng described it to the ALJ? In other words, was that, yes, the conviction was new, I get that, but it was inevitable. The registry, having to register as a sex offender was new, but that was really how well could he negotiate. If he negotiated super well and it wasn't a sex offense, then he might not have to register, but the evidence was the evidence. And so that was new. But was there something about what was disclosed in court in DeKalb that showed that this was something more serious or more extensive than how the doctor described it when explaining his answers on the 3 applications or whatever was said to the ALJ?
No, and in fact, since the sentencing, the judge modified his sentence to let him reside within the 1,000 feet. I think it's 1,000. I think it's 1,000 feet.
Yep.
So that modified, because his house was like, I don't know, 900 some feet from something, and so the judge modified that and let him continue to live there. He's since moved to Washington State, which I was going to tell you about also. But so then he also.
So why does he need a Georgia? Is this not moot now?
It's not moot because the actions in Georgia are going to prevent him from getting a license anywhere else.
Okay.
Which is why he offered to the state a couple weeks ago, I won't even reapply for my license until my criminal sentence is served out.
How much probation does he have?
He has 5 years house arrest plus 5 years probation.
Oh, right. He had a custodial sentence, but it was house arrest. So it's a 10-year sentence.
Yes.
Okay.
And so the state and the board even rejected that. But anyway, so no, bottom line answer is no, DeKalb didn't find anything more serious. They let him live closer, and they actually also did away with a requirement for him to have another evaluation because he's already been evaluated and deemed not a risk of sexual offenses.
His house arrest, do you know, I guess we're getting astray here, but is he even able to go to work or he has to be at home when he's not at work or church or doctor, whatever it would be?
Groceries, church.
Okay.
Doctor's appointments, legal appointments.
All right. So he could serve as a doctor somewhere, even under the terms of this sentence, if he had licensure.
Yes, and he particularly like telemedicine.
I would just add that under the terms of Judge Schroer's discipline sanctions, he was required to practice by telehealth only until I believe his sentence had been completed. So
Okay. That's the ALJ. That's not the DeKalb judge.
No, that's the AL.
that's correct.
Okay. All right.
Okay, so, and also just, we're really out of order here, but interestingly, when he moved to Washington, the state of Washington supervisory protocols are even more strict than Georgia. And so in Washington, he's got to meet with his probation officer weekly, whereas here he was doing it monthly. And more significant is that every keystroke on his computers is being monitored. And if he goes to any website that is inappropriate for whatever reason, it pings in the probation office. And he wasn't doing that in Georgia either.
Okay. On a computer that is actually being monitored, that's what happens. Don't know what happens at a public library or if he's using a friend's computer, et cetera. I mean,
But here, they weren't monitoring that.
okay.
So yes. Okay, so as you know, he appeared for the evidentiary hearing and the board asked Judge Schroer, the ALJ, to revoke his license, and Dr. Tseng opposed that. And Judge Schroer, after an evidentiary hearing, issued her initial decision that he violated some, but not all of the statutes. And in Section B, the section that was adopted by the board, she found the evidence did not prove that Dr. Tseng is unable to practice medicine with reasonable skill and safety to the public. Similarly, the court concludes that the board failed to prove that Dr. Tseng's conduct materially affects his fitness to practice medicine under 43-119A6, or that his conduct violated a statute, law, or rule relating in part to the practice of medicine. So in Section B, which was later adopted by the board, who then, you're right, gets to appeal to itself, but they adopted those findings. So then they appeal before themselves and with no explanation at all, say, and counter to all the experts who testified, they say the evidence says that he's a danger to the public and may not safely practice medicine. So this is a new finding, unsupported by anything that they at least pointed. They didn't point to anything.
But how do you get, I need to hear from Ms. Sawyer in a bit, but, and they adopted Section B. But why do they need to have new evidence to say, well, I guess that's the problem, is
They
that
don't need new evidence.
they don't, but how you practice in this space and I don't know how big Section B is, but pretend it's 100 paragraphs and 98 of the paragraphs they have no issue with. I guess what they should have said is we adopt Section B except for the ALJ's finding that the evidence did not prove that he cannot practice safely.
Maybe they could, it's not,
But do they excise at that level? I don't know the sophistication of, and that's not the doctor's problem, but if why the board can't say, yeah, we said we adopted Section B and we meant like the evidence, the testimony that supported Section B, but obviously we don't adopt the ALJ's conclusion because we're disagreeing with it and we're saying he cannot practice safely. It's not safe for the public for him to practice out. That was their conclusion. And so they are contradicting the ALJ but they're basing it on the same evidence. Does that make sense? That's not what they said, and so that may prove fatal to their petition, but they can use that same evidence and reach a different conclusion.
Well, okay, so I have a couple points to that. Where's the initial decision? It's gotta be here somewhere.
I don't have it.
Okay.
You want me to look
Lost
at
the
there?
initial decision. But the initial decision is not all that long. And section B is not all that long. It's just
Okay.
a couple of pages.
What would it, oh, here it is. It's number 13.
Yeah. I don't know what I've
It's
done.
26 pages.
Right, and section B.
That was Bob Rubin who represented him?
Yeah.
Huh. All right.
So,
right.
but let's stay with your example. Let's say we agree with most of section B, but we don't agree with this one thing. Let's say they had said that. Even so, they have decided to impose a sanction harsher than the judge, than the ALJ who heard all the evidence. So they have an obligation to not do that arbitrarily and capriciously. They have to point to evidence in the record.
When you say section B, there's several section Bs.
Okay, so if you look, here we go.
There's the conclusion of law, section B. There's also the facts, section B.
I believe that what the board was talking about is section B.
Well, but you believing, I hope it's clearer than that.
Your Honor, they adopted all of the findings of fact and all conclusions of law except for section C. So I think we would be talking about the legal conclusion section.
Got it. So what's in, so it's technically section 3B, because that's conclusions of law, section 3, and then B would be what you were talking about, where the ALJ says Dr. Tseng's conduct violated statutory provisions and he's subject to sanction.
Correct. And if you look, so that section B starts on page 15
Yep.
of the ALJ's decision, and it's just page 15 and 16.
Yep.
So, and particularly important is footnote 8 in section 8 on page 16, which is what I just read to the court. So, but even if they do that, they still have to point to evidence. And they never did. They didn't point to anything in the record.
Did they rely on those provisions though? I mean, what footnote 8 says is that Dr. Tseng cannot be disciplined under 43, 34, 8A or whatever they are. And that's all she's saying is because the evidence didn't show he's unable to practice with reasonable skill and safety, then we can't sanction him under these two provisions. But if the board said we're sanctioning him under different provisions, then they haven't contradicted anyone. They're just saying, yeah, okay, the ALJ said you can't use these provisions, but we're using different provisions.
I don't think that's what the board said.
And in order for the ALJ and the board, when they adopted the ALJ's conclusions on those statutes, to find that there wasn't a violation, they, as you said, found that he was not unable to practice medicine with safety to the public. And the rationale in the board's final decision that supported the revocation was that he was unable to practice medicine with safety to the public. So those findings are mutually contradictory.
Okay. So it's the same statutory provisions.
They found violations under other provisions, Your Honor, but in justifying the revocation at the end of the final decision, they explained that the board explained the reason why they were doing that is because of the risk to the public, right? So this is sort of independent of any individual section that he may have violated, but it's what the board presented as their rationale for the revocation, and that's what we're saying was arbitrary and capricious.
If the section, it would be 3C, that the board did not adopt is entitled, it is. So what the ALJ concluded in 3C is that the evidence proved that Dr. Tseng is not a danger to the public and that he may safely practice medicine under a restricted license. And the board said, no, thank you to that. We do not adopt that. if their finding was that he is a danger to the public and he may not safely practice, it's not safe for him to have a restricted license, they rejected the part that they then said, this is what we're rejecting because we in fact find that he is a danger to the
They can't
public.
do that. They can say, we reject that because when you look at the evidence that was produced at the hearing, there is evidence that says he's dangerous. There's evidence that says he's not safe to practice, but nothing exists. They can't do that. They can't just say.
I didn't follow what you said. You said there is in the record before the ALJ that he's dangerous?
No, that's my point. They can say.
But when you say that's your view of the record, why isn't the board able to say, thanks ALJ, we reject C, we look at this evidence and say that is evidence that you're a danger?
They have.
As a non-expert, I'm a non-expert. I've got kids. You're looking at child pornography. You can't be a doctor. I'm not an expert. It doesn't make sense for you to have a license as a doctor. I'm not wearing I've read the DSAM and that's a subcategory and that doesn't count and that's quackery. Just that I look at this record and I conclude that, and hopefully they pointed to something. And maybe that's part of the problem is that they just said, as a whole, in the totality of the circumstances, this record supports the notion that Dr. Tseng is a danger to the public.
The cases say they have to point to something.
And they didn't.
And they didn't.
Okay.
And Your Honor, Dr. Tseng's experts testified at the OSA hearing that because of the treatment for his OCD, he was not at risk to reoffend. That's what they testified to. Because of his psychological condition and the psychological treatment that he was receiving, that is what meant that he was not at risk to reoffend. So the only risk that the board could possibly be pointing to is that he would reoffend. And this is a complex issue. This deals with subject matter expertise in psychology and psychiatry. And that's why the board needed to either do its own psychosexual evaluation or present a competing expert who could have said, no, I've looked at the record and this doesn't match with this type of OCD, or I don't think that he has this type of OCD. But that was not presented. And so
why let's say this were a criminal case and it was a well-funded defendant, like a doctor, and so there were experts, maybe these same experts, and they tell the jury wouldn't be deciding sentencing, but nonetheless, experts for just one side testify. And then the fact finder says, that's interesting, but I'm not persuaded by that. That doesn't make me comfortable enough that you should continue to be able to practice medicine in the state of Georgia. I heard those words, and yes, you're an expert, but I'm not persuaded by that. I mean, what's so magical about the fact that they said those things?
The fact finder can say those things, but here the fact finder did not say those things. In fact, said the opposite. Then the board just says, nah, she's wrong because we think it's a pseudo-diagnosis.
Well, except where she said it is section C, where she says the evidence in the record proved he's not a danger, and they rejected that. Why can't they look at the record and say, respectfully, we're the board, you're not, and based on that record, we feel he is a danger?
Because they're finding, Your Honor, related to his ability to practice medicine safely. And that is where the Tebow case comes in, which says that where there's a complex issue, like Dr. Tseng having OCD, and we're deciding whether a doctor can be a doctor, we need expert testimony to support findings on either side.
And I agree that's what Tebow says, but why do I have to assume that it was a complex issue? If we go back to the beginning, the sort of headline version of this, registered sex offender should not have medical license. That's not complex. Why do I need to assume that the board thought it was a complex issue about whether he was a danger and whether he could practice medicine safely? And the practicing medicine safely is more problematic for the board if they adopted that footnote 8, but they didn't adopt section C, which is all about he's not a danger. Well, and it's about whether he could safely practice medicine.
Well, 2 reasons, Your Honor. One is because the statute said you can't do that. Just because you're a registered sex offender, if it's not related to the practice of medicine, that's a retroactive application of the statute. They can't do that. What they're stuck with is having to go back you know, it would be different really if this all happened today.
Hmm?
But their only recourse is to go back and point to things in the record that if they're gonna do something harsher, they can reject what she said.
Yeah.
And then they have to go back and say, well, we're gonna look at this, this, and this. And that's exactly what happened in the Tebow and Adams cases. And that Adams case is really instructive.
Okay. So it's 10. We have to pause. When I come back, I promise I'll be quiet for a little bit and let you all say more. Then Ms. Sawyer, you've been very patient. I do need to hear from you as well. But we need to take a break. Let me write one more point down.
Yeah, I think it's.
One quick question, so I can be thinking about this while I'm sitting in this other situation. My understanding, Ms. Levy, is that it's an any evidence standard that I'm looking at, and here's what I mean by that. The board doesn't have to point to compelling evidence, overwhelming evidence, a preponderance of the evidence. If they have identified any evidence that supports their contrary view, that in fact, Dr. Tseng is a danger to the public, or he may not safely practice medicine, that's all they need to do. They can't point to nothing. They can't just say, we disagree, signed the board. But it really isn't any evidence review because, of course, what you're challenging is the board's conclusion. And if it is supported by, I believe, any evidence, then I need to stay out of that lane of, oh, you didn't have enough evidence. I can still look at legal errors or was something arbitrary and capricious, but that's no evidence and not an any evidence situation.
Well, I think that the Adams case speaks to that. I mean, it is any evidence to support the sanction, but you have to have a rational basis for that sanction. And
That's true. It wouldn't be because his eyes are blue. He's dangerous because his eyes are blue.
Right.
That's their evidence, but that's not rational. Being blue-eyed doesn't mean you're a danger to practice medicine.
And again, the record was all that to the contrary, that he wasn't a danger.
Well, except the record also was that he, on multiple occasions, consumed child pornography. So that's out there. I mean, that's that's in the
He
mix.
said that poses a danger or risk for him to practice medicine, particularly after he's been thoroughly treated. We're 7 years down the road. They've treated the compulsions. He's not at a risk to reoffend. He's not a pedophile. There's just all the evidence is to the contrary.
And the Tebow case also adds a wrinkle that where it is a complex issue, it has to be, the board's findings have to be supported by expert testimony.
By experts. And here, if in fact Tebow controls in this situation, it seems particularly problematic for the board. I get that. But we're going to hear, I suspect, reasons why Tebow, still good law, doesn't fit here because it wasn't a set of there were complex issues, but a rebuttal of those isn't what was involved. Although it sounds like the record that the board made is going to make that a hard argument to make if the head of the board was saying, I don't think that's a legit diagnosis. But we'll see. All right. I will be back. You all should be at ease until then. All right. So I think that probably makes sense. You and Mr. McConnell and I have been able to explore a bunch of your perspective, more through question and answer than uninterrupted presentation. But I'm anxious to hear from Ms. Sawyer, and then as the petitioner's counsel, I'll hear from you at the very end in case you have things you want to say in response.
Great, thank you.
So, Ms. Sawyer, when you are ready,
Yes.
I'm ready.
First and foremost, before I forget, I did jot a few clarifying points I wanted to make.
Sure.
Based on what Ms. Levy had stated. The first was that this is not a first offender sentence. The charge that he was convicted of exploitation of children under the law cannot, you cannot take first.
Okay, that was my recollection. We get very few of those. Those typically go federally in at least Fulton County. But I'm not aware of, you can be a first offender and a registered sex offender.
Yes,
But I think I said that more so than Ms. Levy.
it's in their brief as well.
Oh, okay. But you're clearing it up. Not a first offender.
And it is also, the sentence is also in the USB drive that was sent to the court with the official evidence that was submitted.
Okay.
The second thing was that there was a discussion that the judge was able to waive OCGA 42119F, which is the residency restriction of 1,000 feet. Again, you will see that order signed by Judge Honorable Brian Lake from DeKalb County. It specifically says for a period of 8 months. So it is not just a waiver wholesale of a statutory requirement for a registered sex offender.
It was more along the lines of, you're going to need to move, but I'm not making you move right away.
It says for a period of 8 months.
Okay.
We will release him from the restriction forbidding him from residing at his current residence.
Okay.
So those are my two clarifying points. Beyond that, the last clarifying point is there was a question as to what the board reviewed during the agency review, whether it was just the transcript or more than that. That portion of it was handled by Bob Rubin, not Ms. Levy at the time. The first agency review, we'd point the court to Rule 616-1-2-.23, which is an OSA rule as to what they must transmit when there is a petition for agency review. Basically, it discusses what is quote unquote the record that must be transmitted for review. In this particular case, also in the USB drive, the OSA files were 1, the initial filing, 2, a notice of business records, 3, a stipulation by parties, 4, a list of exhibits, 5, just the court stating that there was alternative media, specifically that there was a video submitted.
Who submitted a video? I mean, I guess it would be Dr. Tseng because the board didn't submit any evidence.
I need to clarify that as well. The board did have witnesses. We had 2 witnesses.
Oh.
The actual detective that made the arrest, he tendered in the video, body cam video of an interview done with Dr. Tseng, as well as the search of the house, which wasn't particularly enlightening, but that should be part of your record. Additionally, we had the, let me get her title right, Deputy Executive Director testify as to the proceedings of the board. Essentially, how, I think the judge had asked how it took 4 years to get here. If you look at the initial decision, I believe page 11, there was some testimony as to the fact that the first 2 renewal application, we did not flag as a matter in course for our applications when people check yes to being arrested for a felony. He was not convicted at the time. However, the IMLC, which is the compact that allows doctors to get 1 license here and practice anywhere within the compact, their rules are significantly more strict, and he was revoked via the IMLC. That triggered a notification to us, which is when we reviewed it. If you look at the initial decision, the testimony of the officer was, as soon as we got that notification, the board voted that same day for a summary suspension. Nonetheless, you'll see from the initial decision, while those findings of facts were made by the judge, neither the judge nor the board on the agency review really put much weight on the evidence that it took some amount of time to get the proceedings where they were.
Okay, but so two witnesses, they did call 2 witnesses, not any experts to rebut whoever the other experts were, but it wasn't that the board sat silent.
No. We
Okay.
had 2 witnesses, but we agree that we did not tender anyone as an expert witness.
Okay.
And any sort of OCD or any psychiatric disorder.
Okay.
And just very quickly, there was a motion to admit polygraph evidence that was submitted by counsel, Mr. Rubin, a motion to take testimony by remote testimony, objection, a pre-hearing order, an order for remote testimony, another pre-hearing order, initial decision, list of witnesses.
This list you're reading, these are,
They're all available to you
Got it.
in your USB drive. Essentially, it was all the exhibits tendered by both parties,
okay.
as well as the recording, which OSA makes, the audio recording, as well as the Zoom recording for anybody that testified remotely.
Mhm.
OSA allows, if either party is willing to pay for a court reporter, which Mr. Rubin was willing to do that they would accept the transcript as part of the record as well. And that did occur in this case.
Okay.
So that was what was reviewed specifically by the board. All right, as to my argument. So the court is correct, OCGA 501319 does specifically state that it shall not substitute the judgment for that of the agency as to the weight of the evidence. You do have options, including affirming the decision or remanding it for further proceedings. But what is very important, and what I think we're dealing with here, since they're asking you to modify the agency's decision and to essentially reverse the revocation, is that you have to find that the substantial rights of the appellant has been prejudiced. In this case, it appears that they're arguing it has been prejudiced because we were being arbitrary or capricious in making the decision. So I summarized the question for.
The substantial rights would be prejudiced in part because this property interest in the license has been taken away, et cetera. I mean, that sort of gives him standing to say,
Absolutely.
you didn't just put a note in my folder saying you missed work one day. How much does that weigh on you? So there was a substantial right that was prejudiced. And then the defect in the proceedings that I'm hearing Ms. Levy and Mr. McConnell say is that it was this arbitrary and capricious. We disagree with the ALJ. We're not going to tell you why, or the reasons we gave. This is their version. The reasons we gave is we as experts disagree with your experts who were cross-examined, but you don't get to cross-examine us.
Oh, okay. Yes, that is a good summary of what is being argued by them. I'm just simply pointing out, from my review, there's apparently 6 points that you could decide that substantial rights have been prejudiced, including, I think there was like, we went beyond the scope of what we're allowed to do, things like that.
Yeah.
I didn't see any arguments on those points, nor did I see any on the briefing. So I'm going to focus primarily on whether or not it was arbitrary or capricious.
Okay.
So I gather the question is it arbitrary or capricious for the Georgia Composite Medical Board to revoke his medical license when the finding was that he committed a felony and is a convicted exploiter of children and a sex offender? That evidence is frankly not disputed. In the final decision, we specifically say we reject Section C, which was the point made by the administrative law judge. The evidence in the record proved that Dr. Tseng is not a danger and may safely practice. But the board said, we've reviewed it, we reject that portion. And based on that rejection, we also reject the recommendation also noted in Section C, which is that we are able to monitor him via probation instead of revocation.
Right. And why did they reject it? And do they even need to say it? Or if they just reject it out of hand, are we then in the space of arbitrary and capricious? Because nope, and they don't tell anyone why.
Right. So petitioner has pointed to the Horn case, which is, largely about vindictiveness and how you can correct vindictiveness because you can't change the finding. They're correct. You can't change the finding without any explanation. The case doesn't really get into exactly what is an explanation. Do you have to go into the initial decision and point out, I don't like fact A, I don't like fact B, I like fact C, I like fact D? It doesn't say that. I would say the case is mainly concerned about vindictiveness. We don't want someone to decide, hey, we're going to overturn the ALOJ, and we're not going to say why. Here, I feel the court did say why. They specifically said it's because we don't believe that Section C is accurate. We have weighed the evidence, and we find he is a danger to the public and he is a risk to the practice of medicine, we would point out that.
Do they need to go one step further? He is a risk because, or just really the burden is on the petitioner, now petitioner, Dr. Tseng needs to show I'm not a risk. And the board said, you didn't show that. I appreciate the ALJ found that. We reject C. And based on the record established, you have not convinced us, the board, the entity with the final say, that you don't pose this risk.
So I will say, in reading the Horn decision, which is what creates the mandate that you have to do it, you cannot do it without explanation, that's the language. There isn't much direction as to how much detail you have to go into. However, I feel this case regarding vindictiveness, frankly, is not, like, yes, there's this language that says we can't do it without explanation.
Right.
Like that, which I'm going to say I don't feel that is true, but I don't feel the vindictiveness issue is here.
Well, I share that. You don't need to spend a lot of time on that. Ms. Levy can, with rebuttal, try to pull me back, because I don't see the vindictiveness. That vindictiveness means you're mad about something and you didn't agree with us. You're putting me to extra work, and the board's just doing its job, and they disagreed with this ALJ for what to me seems like a fairly unremarkable disagreement. I'm not taking sides here. The ALJ, in a very carefully reasoned way, said, hey, what this guy did is bad, but it's manageable in this way.
Right.
And the board said, what he did is bad and it's not manageable.
Right.
They're disagreeing. That's not vindictive.
I agree with that. And I would just, in addition to that, point out that in Horn, you see that the decision changed because he exercised his right to go to court, right? As he said, you know what, I have due process right, I'm going to court. And then the decision from before court to after court changed.
Because vindictive prosecution, I offer you 10 years, now you make me do more. Fine, your offer's 15 years now. The board has said revoke, revoke, revoke.
From the beginning. In fact, we exercised the right to a summary suspension, which is frankly the harshest thing we can do as soon as we found out that this had occurred. So I'm not sure Horn, while it is there, while we are required to give an explanation, I'm not sure that's the focus of this particular case. Now, what we will say is was brought, yes.
In front of the ALJ, is there argument about what the sanction should be, or is there simply a presentation of evidence and then the ALJ has a roster of options and she selected, I'm going to limit his practice in the following ways?
Right. So the statute specifically gives the specific items that can be done. That's 4334.
But at the hearing.
48A.
Okay, but at the hearing in front of the ALJ, were you advocating for a specific option, or that's prohibited because the ALJ knows the options and you don't need to tell her what the options are?
No. Both parties. I'll have to check the transcript to be specific as to what Mr. Rubin argued for. He was arguing for something less than revocation.
Sure.
I don't recall the specific parameters.
Yeah.
But I'm sure it's reflected in the transcript. Our argument has always been revocation is the only way. Reflected in the testimony of the deputy director, she specified that essentially the board's position is this. And the testimony at the time was that it is part of the mandate of the board to make sure individuals are law abiding. Based on the evidence presented as to the crime that he committed, it appeared he would become required to register on the sex offender, because exploitation of children, of course, requires registration. That's just noticing of the law.
Mm-hmm.
Because he is required to register as a sex offender, the board does feel it needs to, and I believe the testimony was, make sure he complies with residency restrictions, make sure he certainly complies with employment restrictions. There are certain things that the board is aware of that he would likely be required to do on probation, such as, monitoring his internet, monitoring his whereabouts, things like that, that are typical of sex offenders. However, the board and the testimony of the deputy director is not used to doing that. The testimony is, we have never had a sex offender that we monitored. We do not feel that we have the capacity to be able to monitor this individual to the extent we would feel is necessary in order to keep the public safe. Sure, if we were felony probation, that'd be a different story, but that's not the capacity of the board.
Okay.
But that's in short the testimony and can be reflected on the transcript.
Okay.
But we'd simply note when it was brought to our attention that via both the brief as well as during the second agency review, that petitioner was dissatisfied with the brief sentence in the initial final decision, the board then amended the final decision, stating additional facts, hoping to satisfy, because we do want him to understand the reasoning and logic of the board. And when you look at that amended final decision, which has been included, some of the things that they state is that, we are further assured that he committed a felony and a crime of moral turpitude. Obviously, now that we have a conviction and it's not us making the judgment preponderance of the evidence standard based on testimony of officer, we now have an actual conviction. Further, we know he will be on the sex offender. Again, this is not us speculating that he will be a sex offender. The petitioner not only viewed the pornography, but downloaded it and distributed it by use of BitTorrent, which is a file sharing software typically used by child pornographers. This is on page 4 of the OSA transcript, that he is required to register for the sex offender registry. This is in fact publicly available, the sex offender registry, but they're concerned that Georgians don't necessarily think I need to check the sex offender registry in addition to the licensing website. So that was part of the rationale.
Right. I would hope most people don't think before they go to a doctor, let me also check the sex offender registry.
That was part of the rationale, that they don't think that that is sufficiently protective for physicians in particular. And then last of all, because Ms. Levy made some arguments about the POCD, et cetera, they did state that they felt the diagnosis of anti-pedophilia OCD or anti-pedophilia OCD was not made by a physician, which is correct. There was no physicians testifying on behalf of Dr. Tseng. He had 2 psychologists testify, a forensic psychologist as well as his treating psychologist. We would also note the record reflects that they both on cross-examination admitted that they were not there for the purposes of testifying as to safety to practice for physicians, both of them. The treating physician psychologist said, I'm his treating psychologist. I can talk about what treatments and his progress in treatment. However, I'm not here. I don't have the background and I'm not here to talk about safety to practice. The other one stated that she had just been made aware of it. She was involved with the criminal proceedings. She was now made aware of it, but that she had never testified in any proceeding as to safety to practice before. And that was not the purpose of her particular forensic that was done. It was frankly for the DeKalb County court proceedings, but that was a summary of her testimony. But yes, I agree with Ms. Levy. It is noted that the board did state on the record and memorialize in writing that they attempted to answer her question that the diagnosis of anti-pedophilia or anti-pedophilia OCD was not made up by a physician, which is one of their concerns. It's made by a psychologist. The diagnosis is not in the DSM-5, which their expert admitted there is no set. I think it was, quotation is set diagnosis. It's not in the diagnostic manual used by psychologists. It is not widely accepted, nor is it generally accepted by peer review.
But all those things that you are saying, assume they're true. You know about them because the board said that in their final decision,
Yes.
Bringing to bear in their final decision expertise that they have, and I don't doubt they have it, or I'm going to call it at least knowledge that is specialized. I wouldn't know that as a layperson. But let me just finish. So that's in there saying, hey, here are these concerns we've got about the validity of this diagnosis. But how does that get around the TBO, however we're going to say that case?
So they're just reviewing what was testified by the experts to determine nothing that was said here is this something they derived from. This is not new evidence or conclusions. The fact, for example, the fact that the diagnosis is not in the DSMV-5, for example, that statement, let's take that fact, which the board noticed and put in the decision. That wasn't something they came up with.
Oh.
They didn't go on the internet and go, let's look this up.
Right.
Is POCD, oh, it's not. Oh, is that the latest version? They didn't do that. Their expert testified to that on cross-examination.
Got it.
When I asked him, is it a diagnosis? He
Okay.
said, no.
So-
Is it in the diagnostic manual? No.
Okay, so you are identifying facts that the board emphasized in its ruling that I feel like, and I'm not trying to put words in Dr. Tseng's lawyer's mouths, that his lawyer said they're just spouting this expert stuff, but in fact, I could find in the transcript of the cross-examination of Dr. Tseng's experts where that came out. And so the board is saying, look, they may not have referenced, it's page 19 of the transcript, but it's in there.
Yes.
Okay.
So how I am interpreting this, and I believe it's the more fair interpretation, is that they were not inserting their knowledge as experts. Ms. Levy is right. I believe the composition of the board currently, there is one psychiatrist, nobody else is a psychiatrist. I believe that the correct way to state this is that they looked at these findings of facts, and they're not disputing that there was testimony that he's safe, according to these experts, but they're looking at it and they're going, look, I don't have to believe these experts. These are reasons why I don't want to believe these experts. They're testifying as to this anti-philia OCD, which they are also saying isn't diagnosable. I believe both individuals also stated that this is the first time they've ever treated a person
It does sound like a,
without the need to compulsively download child
Right.
porn. They both said that on the stand. So they simply did not find these experts' testimony to be of the level that they would want him to continue to practice.
and let's seize on that. The ALJ did. The ALJ was persuaded by that. How is it that the board gets to say, to get to Ms. Levy's point, like, why do we even have the ALJ process? I think she was more, why do we have this level of review? But it'd also be the ALJ's process if the board can say, that was fascinating, but we don't see it that way.
So I'll agree. There is case law that says that we have to give due regard to the credibility.
Mhm.
So if this was a case where everyone was persuaded that this is a real disorder and it's widely recognized, and the question is he, sufficiently managed? And you have two experts that say different things, and the ALJ says, look, I've looked at the credibility of both, I'm going to side with X. Then you probably should give more due regard. But this is a very different situation in that we're not talking about the credibility of the experts, as in, are they being honest or not? We accept the findings of fact as to their findings. We believe that Dr. Cheryl, for example, has in fact been treating him for as long as he has and doesn't feel treatment is necessary. We're simply looking at it and going, from the board's perspective, is this enough for us to feel that monitoring, as suggested by the ALJ, is enough to keep the public safe? Or do we give more weight to Ms. M's testimony that the board's simply unable to monitor this person to a sufficient extent to keep the public safe? And they made the decision, hey, there's a safety issue. There is a danger to the public and there is a safety issue, which they are allowed to do.
Mhm.
And frankly, they have more understanding of the board's functions and what the capacities are. And we just point out that what we have here is, as the court stated, whether or not the findings are supported by any evidence. The findings that we're talking about, because it's the only one that's different from what the ALJ said, is whether or not there's any evidence that he is a danger to the public and unsafe to practice medicine. I'd point, in addition to what's pointed out in the final decision for Ms. Levy, we'd point out that, the evidence was that a felony occurred, and a fairly serious one. He downloaded porn on 3 occasions, June 2019, September 2019, and February 2020. This wasn't a one-off. The file was called July Jailbait and contained a 39-minute, 39-second video of an adult performing oral sex on a nude toddler, as well as a collage of that video. approximately 270 files indicated as child pornography were registered to his IP address and downloaded from law enforcement from that IP address. When asked, they did a search warrant. They asked him specifically, is anybody in this address? Because IP address, as stated by the officer, is anybody from a residence. It's not, we can't say it's you in particular. He admitted, yeah, it was me. Nobody else is downloading child porn. It's me. Additionally, he admitted to viewing it, described a rape of a girl between the age of 12 and 15, and that the materials that the investigators had the unfortunate task of going through included violent depictions of rape and sodomy involving children under the age of 10. So is there evidence that he is a danger to the public? Absolutely. I don't think there's any way of getting around someone who has been convicted of 4 counts of exploitation of children. There's no danger there. Our ALJ even specifically.
But the ALJ didn't say there's no danger. The finding was this was a bad thing, but it's manageable under the right conditions and limitations on your ability to practice medicine. You can keep your license.
I'd agree. And that was, we're not disputing that was the ALJ's finding, but we would also point out that, it wasn't a situation where we decided there was a violation and we decided this violation and he's a harm to the public, etc. She also found the same. She specifically said exploitation of children, possession of child pornography, not a victimless crime. There's a harm here. She says victims are harmed initially during the production of child pornography, but the perpetual nature of the distribution of images on the internet causes significant, separate, and continuing harm to victims.
Okay.
This is all in the initial decision.
Got it.
We're saying this because it is not, it's not just the board who's saying, hey, there's harm to the public. It is simply, they're not reversing that. We'd also point out that in addition to 43-34-8-4, which is what we're talking about, the main revocation, committing a crime of moral turpitude regardless of the conviction. He was also found by the ALJ to be in violation of the Medical Practice Act under 7, engaging in unprofessional conduct harm to the public, 11, committing any act or omission indicative of bad moral character or untrustworthiness, and 17, entered into conduct which discredits the profession. So in addition to the criminal conduct, here are some other violations that would support revocation.
Right. And I think you made that point that it's not just the
43-119.
Q, right? It's not just that was relied on, but in some ways it's moot whether it was improperly retroactively applied.
I'm going to say it is moot.
Okay.
If I can see situations where it would not be moot. For example, if the charging document that brought us all to court didn't involve the Medical Practice Act, if we're talking about a licensee who's not a doctor, many of the professional practice acts for different professions do not allow the revocation prior to conviction. I would say, without doing an inventory, more do not allow it. So a proceeding such as this, where the board can move forward and say, you committed a felony, regardless of conviction, that's what our Medical Practice Act says, this would not exist. You would have to go under 43-119, which requires a conviction. 43-119 does not allow, if you look at 43-119, it only allows the licensing board to revoke
Upon conviction.
Upon conviction. Yep. So I'd agree with Ms. Levy if the board revoked under 43-119 with a conviction in hand and didn't look at Q, that would be a violation.
Mm-hmm.
Both the judge and the agency did not rely on 43-119 because the Medical Practice Act, by nature of our legislators recognizing that we want more protection for the medical profession, allowed extra regulation. And we will say, I do feel like I've done quite a bit of research on this. Last legislative session, we had SB 207, which they actually amended the Medical Practice Act to include language of 43-119Q in it. Because of situations like this where we don't necessarily want the board to have so much discretion to be able to revoke it without making that decision making. And that's actually did not pass because people are wary of situations such as this one, and medicine is distinctly different, which was also mentioned by the ALJ. The regulation of medicine is simply different. You're dealing with people's lives. So that's why I don't quite understand why 43119Q is, because we didn't revoke him on that. The finding was made by the administrative law judge that we couldn't revoke on that. And we agreed in the final decision. We said, conclusion of law, we can't revoke on 43119Q. I will say that analysis wasn't done, the evidence wasn't put up, fine, you're right. We can only revoke under Medical Practice Act. Yes, but I did want to point out, again, under any evidence, is there any evidence that the respondent is unable to safely practice medicine? Yes. If you look in the transcript, he states, his experts state that he did have issues during a pediatric rotation based on his OCD, that he was flagged for the employer assistance program based on this, that physicians typically require individuals to be held to the highest standards and morals. Committing a felony is not aligned with those standards. That was testified to. It was also testified to that he did lose employment based on his arrest. And so for there to be a statement that there was no evidence that this behavior did not make him unsafe to practice, that's untrue. There are several examples of when it affected his practice of medicine to his detriment. So we do believe we passed the evidence test as to both of the findings made by the judge, by the board, that being that they disagree with the judge, that he's unsafe to practice, that he's a danger, and they disagree with the judge that he is safe for the practice of medicine. Let's see. We'd also note that unfortunately the initial decision doesn't really give us much information as to what to do if he is convicted. We point out that on page 13, one of the recommendations leaves it open until resolution of the charge. Now that we have this additional evidence that he is a convicted sex offender, that the charge is now resolved and he is on felony probation, it doesn't really take into account what is the board to do now that that change has occurred. Footnote 11 does the same thing. She, in response to the testimony from Ms. M, that the board is not equipped to deal with individuals in the sex offender registry, she puts in a footnote on page 11, Dr. Tseng has not been tried or convicted of the pending charge and his name is not currently on the sex abuse registry. We would derive what we can from that decision, that the fact that he is not convicted not on the sex abuse registry, I think she meant sex offense registry. That was a consideration for the judge, but that's not the case now. He is convicted and he is on the sex offense registry. We would also point out that I have not seen any case law, I have not seen any statutory requirement that there has to be a finding that an individual is a danger to the public or that they are unsafe to practice in order to revoke. I only point, surely as a consideration, I'm not doubting that everyone should consider that, including the ALJ, but even the ALJ doesn't look at the 43119Q in her decision because there is no legal requirement for that. And again, we point out that there's more violations than simply the felonies, but also the other revocation, basis for revocations, that being 7, 11, and 17. We would definitely comment that this case is not like Tebow whatsoever. Tebow is about whether or not we could go under the violation of standard of care without an expert. And Tebow is very, very clear that if you're talking about complicated things of a complicated nature, that you need an expert. And I would agree with that. One basis for revocation of all the professions, but medicine for certain, is that if someone does not meet the minimum standards of prevailing care. So just a very, example, if the medical consensus is that you prescribe A when someone shows symptoms of B, and you have a doctor that's prescribing C and never prescribes A, of course we would need an expert to say, hey, you're supposed to prescribe A if you want to meet the minimum standards. And of course, the layperson would not be able to do that because we are not doctors. So how are we able to say A is the correct medicine, not C? So I would 100% agree that a violation of the standard of care when you're dealing with medicine likely is of a complicated nature that requires an expert. Tebow in particular had to do with recommending use of certain devices to correct a mild crowding in a child's teeth for a dentist. So what is the standard of care for that? What medical devices should be recommended if you have mild crowding in a child's teeth? The board in that case did not present any experts. They went on agency review. One of the dentists said, oh, well, you would definitely prescribe X, Y, and Z, or not this, or whatever they opined, and they changed the revocation based on that. That didn't happen here. There was no medical knowledge inserted at, frankly, any point. This is not a standard of care case.
And your pushback to the notion that, yes, there was, because there was a discounting or a rejection of these psychologists who said, this is a diagnosis and it's treatable and he's been treated. The rejection or disagreement with that is founded in evidence in the record, namely some of the responses to the cross-examination.
But also, I would also note that whether or not you want to reject an expert's testimony, that's something all fact finders can find without qualification. So I don't.
They can, as long as what they're not saying, and I'll have to see more about what was said. If what was said was, that's not the proper standard of care for someone who suffers from OCD, anti-pedophilia, the proper standard of care is X. And that doctor said Y. If that's what was in the final report, then Ms. Levy never had a chance to say, well, why do you say that? I mean, I've got this expert here who says it's A, and you're relying on the DSM-4. Oh, mistake, because we're on 5 now. Wrong book.
What was said was the board has doubts as to the validity of the diagnosis.
Okay.
And they state specifically because it's not in the DSMV, it is not, the diagnosis of Dr. Tseng in particular was not made by a physician. So they are not confident by that. Both of those are verified in the transcript.
Okay.
And I believe actually, to make it easy, on page 3 of the amended final decision, footnote 3 and footnote 4 and footnote 2 tell us specifically where in the transcript Your Honor can find those pieces of evidence, if you will. And I would just state, this amended final decision was made because it was brought to their attention that there was a desire for more clarification as to why the board found he was unsafe and that he was a danger. And so they attempted to answer this and satisfy any issues with the due process by making this amended final decision. And that really, frankly, puts me to my last point. So Your Honor obviously has multiple things that you could do. You can affirm the decision, you can remand it, and if you find the substantial rights have been violated because there was no evidence to support the findings of the board, which I contend there is evidence as to both of the findings of the court, and they did not act outside their discretion by revoking, remand would be the option. If you feel, hey, Dr. Tseng should be allowed to have more of an explanation than what was given to him. This amended final decision was not right. I mean, the final decision was not right, and it's clear statement, I reject C. Remand would be to give it back to the board to be more clear. And I feel that.
Do they get another bite at the apple, though? I mean, Ms. Levy pointed out, hey, we already did this, try
That's
again.
exactly what I feel that remedy, that judicial remedy is moot because we had the additional evidence motion. That argument was made to the board that, hey, your final decision was wrong. You simply said this. And so they came back with this amended final decision, which I feel states a lot of facts. And whether or not you agree with those facts or Dr. Tseng agrees with those facts, that is the decision of the board. And it is supported by the record. And thus, I do not believe is arbitrary or capricious.
Got it.
So I believe that's all my responses for today.
All right. Thank you so much. Ms. Levy or Mr. McConnell, anything you want to say to wrap us up.
Yeah, just a couple things, and I'm gonna let Mr. McConnell do most of the talking here, but just an example of the problem that we have here is one of the experts was asked at the hearing, is it in the DSM-5? And the answer is no. And that was it. There wasn't really like an in-depth exploration. Of course, no other expert. Well, I don't think you and I or Ms. Sawyer have any idea what that means, that it's in the DSM-5 or not. And we got some authority that is from the DSM-5 that talks about how that not everything, not all subparts or subcategories of a disease are mentioned in the DSM-5. And
When you say you have some authority, meaning in your hands you have it or in the record? Okay.
I've read from the DSM, but this just illustrates my point, is that you need experts to talk about what that means. Just because our expert said, no, it's not in the DSM-5, so what? That doesn't mean he's not safe to practice or he doesn't really have OCD or a subtype of OCD.
Well,
I mean, the DSM-5 itself talks about all these different subtypes. So,
but I don't need you to read that. I'm not doubting you. But what's the board being misinterpreting or putting the wrong emphasis on something doesn't mean they made the wrong decision. So you're pushing back in a couple ways. One, really, that's an expert thing to say. It's not in the DSM-5. That's super significant. Only experts would know that. Fair point. But then you're going further to say, and actually, it's not significant that it's not in the DSM-5. So that their expert conclusion, if we want to call it that, was mistaken because there are lots of reasons why it might not be in there, because you give a general class, OCD, and then there are an infinite number of subclasses, and the DSM tells you that. But I'm not here to correct factual errors that the board thought 2 + 2 was 5, and it's actually 4. If they feel that it's important to them that this diagnosis wasn't in the DSM, why am I in a position to say that's not important? You shouldn't have weighed that.
And sorry,
Go ahead.
and Your Honor, I think this gets to the issue of the rationale that supported the decision for imposing the harsher punishment in the first place. And the reason why this matters, and I'll start with, you talked about vindictiveness, and you don't see vindictiveness in this case, so why would Horn apply? Why would they have to give this rationale? And I just wanted to point out, in the Horn case, it's not saying that, we look at the particularized facts of any proceeding, and like if a board member said something that was like really out of order, then like now there's a possibility of vindictiveness. And
I've never liked you, Dr. Tseng, ever since you didn't let my kid play on your softball team. That's an issue.
Right. That's right. What Horn is saying is that this is, a unique process. It's a 2-tier, procedure where we have the first hearing and then the board appeals. But as you pointed out, the board is appealing to itself. That's unique. And because of that procedure, there is a possibility of vindictiveness that will always adhere on appeal, whether the appeal is made by the petitioner or by the respondent. And they give reasons for that. And I know I don't want to go too long here, but I would just, Your Honor, they're in the case if you'd like to read them. So Horn does apply. And what Horn says is that when we're imposing a harsher punishment than the ALJ, and this is similar to, if a criminal defendant gets a new trial and then they're sentenced, more severely than they were at the first trial, a similar type of thing. But, and the board essentially needs to present a adequate legal reasoning that explains its rationale for imposing the harsher punishment. That's what Horn says. The reasoning that the board gave the first time around in the final decision was that he is a danger to the public and he can't safely practice medicine.
Was it that, or was it we can't monitor him? Appreciate that she said that. We reject that. We don't think we can monitor him to ensure the safety, because everyone agrees this was serious and there are reasons to be concerned, but we, the board, don't think either it's the highest and best use of our time, not enough bandwidth, or it's just, that's not our role. And so we need to revoke his license.
So at the first final decision, the one that we got, not the amended one, That didn't say anything about monitoring in the final decision itself. There was a little bit of testimony about that from the member of the board who did testify at the first hearing. I would also say that there was argument about, well, the board can't, monitor people effectively on the sex offender registry. And respectfully, that's not the board's obligation. Those are laws that are imposed, that require him to be monitored by the parole board. And the parole board is equipped to do that. But the reasoning in the first final decision was that he was a danger to the public and couldn't safely practice medicine. Those were the reasons that the board gave. I think there was another point here about, pointing to, and this is what Ms. Levy was talking about, this isn't in the DSM-5. We question the validity of his diagnosis, et cetera, et cetera. As she stated, those were additional reasons that came out that were announced on the record and given in the amended final decision. But again, it's unclear why it matters. Like, why can't a therapist give a diagnosis that isn't in the DSM-5? What his therapist did testify to was that he has OCD. He'd had OCD before this happened. He had never mentioned this to a therapist before this happened. When he was arrested, then he had hit rock bottom. So he testified about he explained to his therapist about what had happened. And he was treated for that. And they didn't have any concerns about this reoccurring. So whether or not we're going to officially diagnose him with POCD or just OCD and having these symptoms, it's unclear why that would affect the risk that would inhere in Dr. Tseng continuing to practice medicine. So that's the issue with that point. Moving to 43119Q, what that statute states is that it applies notwithstanding any other provision of law, and the board cannot revoke a license in whole or in part due to someone being under a conviction or a sentence. And at the time of Dr. Tseng's offenses, as you know, this new amendment hadn't been passed. It was passed subsequently, and that's the retrospective application of law issue.
Right, but Ms. Sawyer spent some time helping me understand that if you look at the reasons they gave the board, either in revocation 1 or more importantly, revocation 2, they don't say, well, look, we're done, 43119. He's been convicted of, and he's a registered sex offender. They didn't say that. So let's say you're right, that's how it applies. Aren't there other bases? You disagree with the other bases, but aren't there other bases upon which the board relied, in particular to say it's not safe for him to practice, we can't monitor him, and so here we are. Now, the reason why they believe it's not safe is because he's a registered sex offender, but that's not saying because just ipso facto, you're a registered sex offender, felony conviction, out the door.
And I think what the board had said was that now that we know for a fact that he is on the sex offender registry, we have concerns about, how the public will find out about this. We don't want them to have to search that. So they did argue, and they stated at the second hearing before the board that this was a factor in their decision to revoke his license. And the statute says due in whole or in part to his being under probation on the sex offender registry. Right, and I think there was also argument that 43119Q doesn't apply if there's violations of the medical board's statutes as opposed to 43119. And to reiterate, 43119Q applies notwithstanding any other provision of law, meaning that even if another provision of law would allow you to sanction someone in whole or in part due to this sentence, under 43119Q, notwithstanding, so okay, we have to apply 43119Q, and that can't be one of the reasons that supports the revocation. I think, Susan, are there other points?
I don't know if you wanted to talk about Adams or Thibault.
Oh, I'll talk about Hicks for a second. Hicks is a case that was cited in Tebow. The board argued that, this isn't a case where we're testifying or where we're arguing, I keep saying testifying, where we're arguing that, a doctor gave somebody the wrong medical device. Still, the board's finding was that he couldn't safely practice medicine. So that does implicate his ability to practice medicine professionally in light of the diagnosis that he had, which was unrebutted at the first hearing, and testified to by his treating provider. So this is a complex issue. It requires specialized knowledge to assess whether somebody does or does not have OCD and whether somebody's treatment for OCD would or would not be effective. A case that's cited in Tebow, as I said, is this Hicks case. And where did that go? Sorry. Okay, so Hicks, the Tebow court talks about Hicks. Hicks is basically a case where somebody whose claim for benefits was denied. They said they had incurable depression, essentially. And they had an expert testify. They supported this claim that they had, not treatable depression. The agency did not have anyone testify. And as the Tebow court explained Hicks, even though the only expert who appeared at that ALJ hearing testified that the claimant's involutional depression was totally and permanently disabling, the agency itself found that involutional depression was, quote, not a permanent disability since it begins around the time of menopause and should improve when menopause is completed. Also, this depression does not appear to be psychotic, but simply neurotic, and therefore it is not totally disabling. And the appellate court in Hicks reversed the trial court, saying that they couldn't simply take notice of these facts that were outside the record and apply them to reach a conclusion that, because in that case, I'm sure there was testimony that this individual, would eventually approach menopause, that she hadn't already been in menopause. And so they could, extrapolate off of that and say, well, eventually it will be cured because we know as experts that, that menopause cures this type of depression. Similarly here, we have, it's not in the DSM-5, we have his treating provider saying it's not curable, but it's treatable. And in fact, what he said was, we never talk about cure in mental health. We talk about management. And when somebody is effectively managing it, as Dr. Tseng has been, as the ALJ would have required him to continue to do, then there's no concern about him reoffending. So the facts in Hicks are the same as the facts here.
Did they say there's no concern or just that it's manageable?
Your Honor, I would have to go back to the transcript to find the specific quote. I would be happy to do
No,
that.
I mean, I'll find it, but that's pretty bold for an expert to say, I have no concern versus then we're in a safe space.
Yeah, I know that they asked him, do you have any concern that Dr. Tseng will reoffend? And he said, I have no concern that he will reoffend. Whether he said, sure, I could never absolutely rule something out. I'm sure there's something like that in there.
Right.
But that he did say he had no concern.
Okay.
Your Honor, also on that, I mean, Ms. Sawyer tries to distinguish Tebow, whatever, which has this Hicks case in it. And I think they're much more similar than at first blush you might think, because in Tebow, they're looking about this competency of a dentist. But in this case, the reason the board is saying that Dr. Tseng is not safe to practice or poses a danger is because of the nature of and whether he really has this disease. And so the issue is, the experts say he has this disease, it is a real disease, and he's been treated, and the board saying, well, we think it's a BS disease. We don't really believe it, and it's not curable. Well, there's so many diseases that aren't curable, but it doesn't mean that it can't be managed and treated, whether it's alcoholism or diabetes. I mean, if you don't take your insulin, a lot of bad things can happen. I've had cases like that. So I think the case is really right on point, and its reliance on Hicks further supports that.
Okay.
Anything else?
I don't think so, Your Honor. I think I can conclude there. Thank you, Judge.
All right. So here's how we will proceed. I think I have all the record. I'll dig around in it. If there are things I can't find, Ms. Niles will reach out to both sides saying, hey, you talked about X. We can't find X. Help us find it. And the answer is either, oh, you can't find it because it's not in the record, or, oh, you need to look at page 19, or it's this file. Second, if I bump into a legal issue that I'm stumped by, I may reach out for an email brief. No one needs to file anything, but like, hey, give me your thoughts in a paragraph or two cases or whatever that you think would address this question I've got. And then we'll take it from there. Okay?
Your Honor, I'm headed off on leave for a couple of weeks, so if you would not mind making sure Mr. McConnell gets copied on anything.
I will make sure that he is as well. And given the time of year, no one should be expecting a little package being delivered with a final order in the next 2 weeks. Okay? I'm just letting you know, as we gear up to wrestle with this, there may be outreach before there's an actual order. Okay?
Thank you.
Thanks, everyone. Appreciate your time. I'm sorry this morning was so disjointed.
No worries. I like this format. It really kind of helps get to the meat of the issues.
Oh, I'm not apologizing for all the questions. I meant this break, the break that we had to take. You had to sit around, and Ms. Sawyer is going to really bill her client for that extra time. So
Thank you. Have a good holiday.
you too.
All right, bye. See you, Sylvia. Take care. All right, you too.
Yeah, it's got a lot order. You got a wall. It's a power. So they that their trial two bullets.
Detective Hanson,
Yes, sir.
how are you?
Good, sir. How are you?
I'm all right. Thanks for your patience. Very detailed affidavit.
I have a little bit more to add. Shoot.
I don't think you need it, but if I'm comfortable signing it now.
Okay.
If you want to add something, you got to write it on here, because if I take oral testimony, we have to record it and somehow attach it.
Yeah, it's just strengthening data,
Okay.
for lack of a better term.
Yeah.
But I'm comfortable standing on just the written at this point as well. So
Okay, let's do that. It's pretty thorough, but this is just for one of the two. Has the other guy been scooped up, or they'll be?
no, and I don't have really anything on him.
It's so surprising, given how this went down and all the people who know him, that there's nothing.
From my interpretation of this whole thing, and I wasn't the lead investigator on it, just how the fugitive file. The family hated each other before all this happened.
Yeah.
And this was just icing.
Oh, yeah,
cake.
no, and you
So-
put in here, like, this is basically split the family.
Yeah.
But there's still, because of whatever side would be with these guys, their phones ought to be showing, hey, they're calling these numbers all the
And
time.
we got mom's phone, Candace Whitehead's phone,
Yeah.
from the historical records. So my goal is to get Terrell first because we have a little bit more on him. And
Okay,
then
you
go
do, you got a bunch.
Flip mom's number and then see if we can get Tristan off.
Who's
of that.
left?
Yeah.
Okay.
Because what threw us really on everything, we were geared up. I had drone video and everything to go hit the house on Olympian Way.
Yeah.
And then they moved out.
There was nothing.
Oh, crap. So
That address too, I've had a murder trial, same, not that actual street number, but Olympian, that's a tough neighborhood. Yeesh. All right, you swear or affirm that the contents of your affidavit are true and correct to the best of your belief and knowledge?
yes, sir.
Great. Do one more thing here.